we get started, but we're going to go ahead and get started and be respectful of everyone's time. So hello, welcome to the first best practices call for the Southeast District. I am Heather Beck. I am the chair of the Southeast District. I'm really happy to have you guys here with us today. And I will remind you, if you are not Jay, go ahead and mute yourself. Just to make listening easier for all of us. And Mindy, are you ready to start? It's recording already. All right, it is my pleasure to introduce Jay Bender. Jay is a media attorney with Baker, Ravenel, and Bender in Columbia, South Carolina. For more than 30 years, Jay has been the attorney for the South Carolina Press Association and the Broadcasters Association. He is retired from the University of South Carolina, where he held the Reed H. Montgomery Freedom of Information Chair with a joint appointment in the journalism and law schools. Jay is widely known in South Carolina as an unabashed advocate for freedom of the press, and I'm really looking forward to hearing from him. So with one more reminder to mute if you guys have just joined us, I'm going to turn it over to Jay. Take it away.
Thank you, Heather, and thank you, Reba, for the invitation. I was asked by Reba to talk about the First Amendment, and of course, I'm happy to do that, and it's particularly timely given what's going on in Washington, and I will keep this to the strict time limit that Reba gave me so we can all get back to watching the trial in the Senate. But we'll start with a history lesson, and I always start there because you cannot consider the First Amendment or any other amendment in the Bill of Rights in isolation. They're all part of a historical context. And we know that what is now the United States of America started off, at least in the English-speaking portion of it, as British colonies. And in 1776, 13 of those colonies got together and proclaimed independence with the Declaration of Independence. So how do we get from 1776 to a First Amendment? Well, there were several intervening actions. Most important, of course, was the Revolutionary War. And then following that war, we had, instead of 13 colonies, we had 13 semi-autonomous nation states. If you would, South Carolina, Georgia, North Carolina, and so on, flying in close formation with no overarching government. And in 1777, the Articles of Confederation were written to try to bring some unity to these 13 nation states. That was ratified in 1781. And that bumped along with still unfortunate consequences because of the independence of the state. And as a practical matter, all the political power resided in the states. If New York wanted to enact a tariff on goods coming from New Jersey, it was free to do so. And each state had the authority to coin their money. And there was no centralized chief executive. So in 1789, a constitutional convention was called. The premise was to revise the Articles of Confederation to make for a more efficient government. But there were a couple of people, James Madison and a fellow from Charleston, who thought there were better ways to do it. And they really wanted to devise a new form of government. And in the Constitutional Convention that started in September of 1787, they came up with what we now know as the Constitution. It was sent to the states and ratified in 1788. So we have this period from 1776 to 1788 where the states had power, and the states were not at all anxious to give up their power. And one of the criticisms of this proposed constitution was that it did not provide protection for individual liberties against this new centralized government. And the context for this fear was we had been under a monarchy since colonial days where there was centralized power and an autocratic king. And there were several drawbacks to that in the minds of the colonists turned patriots turned citizens of the United States. Now, there are political theorists who say that the notion of having a Bill of Rights to attach to the Constitution was a political gimmick, figuring that that would never pass, and as a consequence, the Constitution wouldn't be ratified. But it, in fact, the Bill of
Somebody asked me if I had a PowerPoint presentation to make when I was in the competition to be dean of the journalism school, and I said, no, Bill Gates can't get them to work. What makes you think I can get them to work? But this is the first time I've had difficulty with Zoom, but let's speed up the presentation. I've given you the history lesson. Let's talk about what the First Amendment does. It protects 5 great freedoms: speech, press, religion, assembly, and petition. And very often they're lumped together as freedom of expression. And for those of you who paid attention in your media law class or who have pulled out your pocket copy of the Constitution to see what's going on in the impeachment, you will notice that the first word of the First Amendment is Congress. Congress shall make no law. So it's a restriction on the federal government. And it was only a restriction on the federal government. Many of the states at the time of the adoption of the Constitution had their own similar free press, free religion provisions. But the threshold is the First Amendment only guarded against interference with any of those 5 great freedoms by the federal government, because the federal government only acts when Congress gives guidance to act, adopts a statute. And then we had some unpleasantness started by a bunch of people who wanted to preserve slavery. A bunch of nuts got together in Charleston and decided to form their own country so they could keep black people under their thumb. And they got their ass kicked. And as a consequence of that, we had several amendments adopted after that war. And in 1865, we had the 14th Amendment adopted. And for the first time, it included a restriction on the power of the states. And it has in the due process clause that no state shall deprive any person of life, liberty, or property without due process of law. What does that mean? What is due process of law? Over time, the Supreme Court of the United States, in a series of decisions, incorporated the protections of the Bill of Rights into the due process clause of the 14th Amendment. The notion is known as the incorporation doctrine. And even though there is nothing expressed about protecting speech, religion, assembly, and petition in the 14th Amendment, the Supreme Court in 1925 said that the states were restricted in the same manner as the federal government was under the First Amendment. So we've gone from 1776 to 1925 before we get restriction on state power with respect to speech, religion, press, petition, and assembly. So what does all of that mean? And in this context, you've heard most recently that Twitter and Facebook banned Donald Trump. And his first complaint was that he was being censored. And in a sense, that is true. Where someone in advance of your publication restricts your ability to publish, you have been censored, or in the classical term, you have been subjected to prior restraint. It is not illegal when it is done by a non-governmental entity. When the government, either federal or state, restricts speech on the basis of its content or its viewpoint, that is illegal. That would be an unconstitutional restriction on speech. So Donald Trump or that Senator Josh Hawley, who lost a book contract after he tried to overthrow the election, have not had their First Amendment rights violated. Simon & Schuster is free to publish any book it chooses. And the fact that it chose not to publish Josh Hawley's book because of his stance in the Senate is not an infringement of his First or 14th Amendment rights. So let's carry it one step further. Newspapers and broadcasters are subjected to liability for what is published if it is an invasion of privacy or if it is defamatory and false. And as a consequence, newspapers and broadcasters vet and curate what goes in their pages or over their air, whether it's done by staff or by correspondence or letters to the editor. But when the internet was developed, Congress seemed so enamored by the concept that it gave the companies that operate interactive websites a free pass with respect to content. Under Section 230 of the Communication Decency Act, the operator of a website that allows third-party content is not liable for the content that is posted on that website. And that's how Twitter and Facebook were able to allow Trump and others to publish defamatory falsehoods without Twitter or Facebook or any of their ilk having liability for it. And you're hearing a call for a change in Section 230 so that the protections for these interactive website providers will be diminished. I think that will be an uphill fight, but I think there will be discussion about it in Congress going forward. I've always had a problem with news organizations having a comment section on their page and allowing any fool to post anything they wanted on that website, because news organizations spend years and lots of money developing credibility. And then to allow anyone to come in and post any kind of gibberish on your website, I think diminishes the credibility of the news organization. But that sermon has not been acted upon consistent with my belief that it's a bad idea. And some of you may have clients who operate websites and allow third-party comment. You don't have to curate them. You can take it down or leave it up as you see fit. If you get a comment that is inappropriate, I would suggest that you police these websites from time to time to take down those comments that are most offensive or inconsistent with your business, because again, I think it erodes the brand of your business. In theory, you are insulated from liability. That doesn't mean that your company won't be sued, but you will have a defense. And if you are fortunate enough to get a judge who will pay attention and read the law, the case should be dismissed out of hand. I've had a couple of those, but in South Carolina, the quality of the judiciary is uneven, and it's not a surprise to go into a court where you get a judge who hasn't read anything and doesn't seem to be interested in reading anything about the case. particularly if there's a lawyer legislator on the other side. But where your companies have exposure is not on the website, it's what you publish, whether it's in an ad, a newsletter, or any other kind of communication, and then you're subjected to liability for libel, invasion of privacy, and copyright infringement. And I very often tell people to train your staff to believe that just because you find it on the internet doesn't mean that it is free, and to stop stealing, because there is no such thing as innocent infringement. And the notion that your use of something that you find on the internet is a fair use is often mistaken. I point out that fair use is a defense, which means you will use it if you've been sued, and the object is to avoid being sued. So bottom line, the First and 14th Amendment protection of speech is a restriction on government, not on private entities or individuals. And if you are Walmart, you can tell people they can't pass out leaflets in front of your store, but if you're the University of South Carolina or the City of Columbia or any other government, you cannot restrict the distribution of literature or comments on your streets and sidewalks. And to a large extent, you cannot, if you're the state of South Carolina, you cannot restrict protest and comment at the State House. One of the leading civil rights cases came from South Carolina. It's called Edwards versus South Carolina. And young people walked from Zion Baptist Church on Washington Street to the State House, where they were protesting segregation. They were arrested for disturbing the peace. The case went all the way to the U.S. Supreme Court, and the Supreme Court said quite clearly a state could not arrest its citizens for peaceful protest at the seat of government. Nikki Haley and her lawyer had apparently never read that case when they had the Occupy protesters arrested, and very quickly the case was dropped, and then the state was sued civilly for those arrests. Now, because of our technological difficulties here, Reba wanted me to take time to answer questions, so I've given you the Reader's Digest version of the First and 14th Amendment restrictions on governmental authority. So if you have questions, I'll be happy to try to answer them in the context of our technological limitations here.
Does anyone have any questions for Jay? I appreciate everybody being so patient with us while we had some techie stuff going on today.
Yep. Hi, this is Meredith. Thanks for your comments, Jay. My husband used to be in public service, and our local media had comment areas on their stories, such as the ones you described, and someone would regularly post that my husband was on the take. I always say he was corrupt, he's taking bribes, which bad news for our community, but I always felt particularly bad news for me because I never saw that money come into our house, and I thought, well, he must also have a mistress because this just doesn't add up. But and I'm intrigued by your comments about allowing those as PR people, or as a PR person, I always think, yeah, I want engagement, but you're right. Sometimes you get people who are, I wonder if they've even read what they're commenting on. Is there any movement toward, and I don't know if it would be among journalists or in terms of liability for organizations that allow that kind of, fact-free comment?
The only liability would be imposed on the person who posted false and defamatory information or information that invaded someone's privacy. The difficulty is the ease of anonymity in posting, so it's difficult to find these people, and very often when you find them, they don't have any resources to make it worthwhile going after them. There are, of course, exceptions to that, but most often it's not worth tracking them down and filing suit.
And I know they said you're both a law and journalism professor, I guess recently retired from both. In the journalism field, is there any thought about restricting those, or are they just letting it happen?
I think news organizations wrestle with it on a regular basis. I know there are some stories some news reports that get published that, because of the sensitivity of the news report, the newspaper will block comments, particularly in those communities where every news report seems to generate racist comments. Charleston, for example.
That is good to know. Thank you.
They curate the pages and take down the bad stuff, but again, because it's protected and because of the current state of the economy and newsrooms, there are not a lot of resources being assigned to that. You're asking people in newsrooms to do more and more with less and less, and taking time off to do something where you have no exposure to liability is probably a fairly low priority.
Thank you.
You're welcome.
Jay, I think we have one other question that has popped up in the chat. Karen wants to know, is the level or degree of censorship that we're seeing something that we should expect to see more of? Or do you think it's going to lessen over time? Is there a trend that's associated with this that you're seeing?
Are you saying, do I expect more or less censorship?
Yes.
Is that the question? That's a great question for which I have no ready answer, because I don't have a crystal ball. I think that given the political division in our country, there will be claims of being silenced or being censored, but those acts will not be violations of the Constitution, because it won't be the government deciding, for example, that Josh Hawley is not entitled to have his book published by Simon & Schuster, or Donald Trump's not entitled to be on Twitter because of his promotion of violence. But I think, and also because there's now governmental pressure being brought to bear on Facebook and Twitter, those companies may be more energetic in their enforcement of their standards, even though both Twitter and Facebook have purported to have community standards. There's very little evidence that they do or that they enforce them.
Jay, I have a follow-up to that question. So I can see there's definitely a positive side effect to this type of censorship, in that it diminishes the spread of misinformation. Do you see a flip side to that? I mean, is there any way where you would say, from a private industry or private company perspective, where, like Facebook or Twitter, that this could be damaging to them in retrospect?
Well, we've always had a bias in favor of more speech, not less speech, and particularly when the government gets involved in trying to regulate speech, we believe that the truth will out. But as one of the impeachment managers said today, a lie will be around the world before the truth gets its shoes on. And so private organizations probably need to pay more attention to the dissemination of disinformation and misinformation and outright falsehoods, on platforms that they operate. Whether they do so will depend on how it fits with their business model. My guess is Facebook was quite happy to sell ads to politicians that contained disinformation and misinformation, but now that it's under scrutiny, it may be willing to say that money is not worth it.
Hi, Jay. This is Jane from Knoxville area, and I just wondered if you had a resource that you could share for. I'm with a local government, a municipality, and of course we fall under the we can't censor issues, and I understood that we could take down posts that were insightful of violence or hate speech or anything like that. And I'm just curious if there's a really great place that you can go to keep up with that.
I don't know of a single source, but I can tell you that there is no First Amendment protection for speech that incites violence or constitutes fighting words. That is, speech that will likely promote an immediate illegal response. But I don't know of any particular resource. Now, you say you're from Knoxville?
I'm in Maryville, which is next door.
I'm sorry, I didn't hear that.
I'm next door in Maryville, Tennessee.
Oh, okay.
We have a lot of those.
I'm actually giving this presentation to, what is it?
Volunteer chapter.
Let's see.
Yeah, that's it.
Reba is my agent, and so she's lined this up. And I
Yeah,
was
that's
happy
it,
to do
Jay.
My son-in-law is an Episcopal priest and has St. James Episcopal Church in Knoxville. So I was happy to
Yes.
get people in Tennessee. They need all the help they can get.
All right, I'm gonna make note for our meeting on Thursday or next Thursday.
All right. And hopefully the technology will work. I don't know what happened here today.
Yeah, I am sorry, everybody, about the technology issues. But unless there are any more questions, we will go ahead and wrap up for today. Thank you guys for your patience. We really appreciate you guys coming in, and we'll see you again in March.
Thank you.
Thank you.
Bye.
Thank you, Jay.